Madam, you will recall. Number 2, you may sit down. You will then recall that your case was postponed for judgment, and the court is now going to read the judgment as follows. This is a judgment in a bail application where the applicant is Matshidiso Lechamochamo, residing at Ramotlakwana in Mount Fletcher. She is 41 years old and charged in a case of murder falling under provisions of Section 51, subsection 1 of the Criminal Procedure of the Criminal Law Amendment Act 105 of 1997. Together with accused number 2, Wanlwazi Xaki, who abandoned his application for bail. There is also accused number 3, who has been added on the 12th of May 2022, Noxolo Phindela. Hence, she does not appear in these proceedings. Applicant is represented by Mr. Langamandla. Bail proceedings continue in terms of Section 60, 11A of the Criminal Procedure Act 51 of 1977, as the offence is listed in Schedule 6 of the bail legislation. In terms of section 6011A, applicant is to accuse evidence either by testifying in person, calling witnesses, or submitting any other admissible evidence, whether by affidavit, to satisfy the court that exceptional circumstances exist which may, in the interest of justice, permit a release on bail. On the defense in opening applicant's case, called in applicant Matshidiso to testify. The court will not repeat all the evidence that was led as it does appear in the court record, however, will summarize evidence that will lead to a ruling. She testified that she is 41 years old and stays in Skiti location in Maluti and is married customarily, but the husband is deceased. She stays with her 3 children. Ages of children range between 13, 11 and 5-year-old. Gave evidence that since she is in custody, she has arranged with the lady she works with at the container to take care of the children. She is not good in health. As a result, she takes treatment. She is self-employed. She has a tender of grass cutting and also employed 3 people and also a container where they cook food, and there are 2. Testified that the application is that she be released on bail, as she will attend court and abide with all conditions of bail if it is granted to her, and she also has livestock and also has property, being a car and also cars, a house and cars. That she knows nothing relating to the case of murder. She does know the witnesses. She has no previous conviction and no pending case. And during cross-exam by the state, she was asked as to which witness that she knows, and she said she knows accused number 2. And she said that she does not know accused number 3, and was asked if she never met accused number 3 at all in her life, and she said no, she never met him. When asked as to how she knows accused number 2, her response was that accused number 2 is the child of a lady who is married in the same household as hers, so she came with that lady. She was further asked if she never stayed with accused number 2, and she confirmed that she once stayed with him. She was further asked if she knows the deceased in this case, and she confirmed that she knows him by the nickname of Slow Motion. And when asked how does she know him, she testified that he used to come to her husband when he was still alive, and is also good in fixing electricity and carpentry. She was asked if she did continue communicating with him after her husband's death, and she confirmed that when she had electricity problems, she would call him to help out. And the state asked her as to when did she last see him, and response was that it was in December 2021. And when asked how did he see him, she testified that because she wanted him to fix his electricity in her house, so she called him to come to her house. The state further asked if did he then fix that electricity. She said no, he never fixed it, because it was late on the day to buy wires, as he had said that the wires are all bent, and after that she never saw him again. The state further asked her if it did not bother her that he was there to fix electricity and he never saw her again, and she said she found someone else to fix the electricity. The state asked him about accused number 3. She still maintains that she does not know him and never saw him at all in life. Now applicant changed to say, I'm sorry, she normally used to see accused number 3 with Slow Motion with the deceased, to the extent that they arrived at her home together with Slow Motion on the day in December 2021. State then put it to her that the deceased Matshidiso, whose nickname is Slow Motion, was brought to her yard and she killed him brutally in the presence of accused number 2 and accused number 3, but number 2 has turned into state witness. She confirmed that accused number 2 and number 3 were selling drugs for her husband and denied that after her death, the death of the husband, they continued selling for her. And also the deceased slow motion also was selling drugs for her husband. The state asked her if she now knows them, yet at first she had said she does not know accused number 3, yet she says that she was selling drugs for her husband. So what did she mean when she said she does not know accused number 3 at all? She had no response for that. State put it to her that as she kept on communicating with them even after her husband's death, it is because they kept selling drugs for her too, and she denied. And the state put it to her that she killed the deceased together with one Nokolo, who is at large, and if she is released, she can also run away. And the reason to kill the deceased is that he had run away with some amount of drugs. She also denied that she did not assist the investigating officer in trying to find Nokolo, as she did furnish numbers of the sister of Nokolo. The state further informed her that even in prison, she can still get her treatment if necessary through the investigating officer, and she agreed. Further informed her that after they killed the deceased, they put him in the Triton van, which belongs to her, and dumped him at Mvenyane. She denied such. When applicant closed the case, the state opened respondent's case by calling the investigating officer, one Mr. Zamqolo Ponza, who was the rank of sergeant at Matatel SAPS with plus minus 13 years of experience. He testified that he is opposed to the release of the applicant on bail, reason being that she will interfere with police investigation as there are still outstanding suspects. And one of the suspects is her stepdaughter. And police looking for her as she's still at large. That she may interfere with state witnesses if released, and witnesses are afraid of her, they have told the investigating officer. One of the reasons is that her safety is also not guaranteed, as the community is very angry at her and have been making threats to burn her house if she is released on bail and will also kill her. Further, that applicant should not be released on bail as she is a danger to society. Firstly, that on the date of arrest, police searched her house and found out that she has a licensed firearm, and they found 3 magazines. 2 were belonging to her firearm and the other one was not belonging to it. And they were all loaded fully with ammunition. She could not give an answer regarding the 3rd magazine, which gave a reasonable suspicion that there is an unlicensed firearm to which that magazine belongs to, and she uses it to kill people. Two boxes of bullets were found, each containing times 66 bullets. And when asked what does she do with so many bullets, she failed to explain. Before she was arrested, the community where she resides came to SAPS to report that she is selling drugs in a place. And the community had a problem that she is destroying the children around the area. And when the community went there to reprimand her, she took out a firearm and she loaded it in front of them with bullets. Community left a place fearing that she will kill them. After that, the police went there as they had heard the report. They went to a place to find out why she did that to the community. She then fired shots at the police. Witness further testified that she is a danger in that she uses a firearm anywhere, anyhow, and to anyone. And the community reported that every day at night at her place, shots are being fired, and they fear that And since she has been arrested, there's been a difference. It has been quiet. No shots were fired at her place. Further, that the deceased was murdered brutally. According to the investigation, deceased was taken at his home in Area C, forcefully taken to applicant's home. And according to an eyewitness, deceased arrived in one of applicant's motor vehicles. He was covered in blood from the face down his body. He had no clothes in the upper body. He had no clothes in the upper body. Applicant was amongst the people who assaulted the deceased with a hammer and also a bush knife which was hot heated on a stove. And they used this hot burning bush knife to assault him. And the people who attended the scene where deceased's body was found confirmed that indeed there were burn wounds on the body of the deceased. An applicant, after assaulting the deceased who died at a homestead, transported deceased's body to a forest at Upper Mvenyane, trying to conceal. The family members of the deceased have identified the body to be that of Simongile, who was last seen at applicant's place, and in her evidence she also confirmed that she last saw him at her place before Christmas. And during cross-examination by the defense, he asked the witness what evidence does he have against the applicant, and the response is that he has evidence of eyewitnesses. Defense put it to the witness that accused number 2, who has turned to state witness, is a drug addict and his evidence during trial cannot be relied upon. And the response from the witness was that on the date of trial he will not have used drugs. The defense further asked, why is there no case of pointing with a firearm? As she's alleged to have pointed a firearm to the community. And the response by the witness was that the police officers of Malito are dealing with the case as it happened in their area of jurisdiction. The witness was then excused. The court will not repeat the arguments, save to state that the defense prayed that applicant be released on bail, that she has accused evidence showing exceptional circumstances. On the other hand, the state prayed that accused person has not proved any exceptional circumstances. They are normal as she can get treatment whilst in custody. And that there is someone looking after her children. And even in the business, she has employed people. And that since she is a danger to society, she should not be released. We shall now look at the relevant legislation that is applicable herein, apply the law to the facts that are before the court in evidence. State indicated at the beginning of the application that the charge against the applicant falls with the defense also considered that the charge is a premeditated murder. Section 60, subsection 1 of the Act provides that an accused who is in custody in respect of an offence shall, subject to the provisions of Section 50, subsection 6, be entitled to be released on bail at any stage preceding his or her conviction in respect of such offence if the court is satisfied that the interests of justice permit so. Section 6011 provides that notwithstanding any provisions of this Act, when an accused is charged with an offence referred to in Schedule 6, the court shall order that the accused be detained in custody until or she is dealt with in accordance with the law, unless the accused, having given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist which may, in the interest of justice, permit his or her release. State versus Lamini, State versus Lalda and others, State versus Rubet, State versus Shikat, 1999, volume 7, found nothing wrong with the phrase, and it came to a conclusion that what constitutes exceptional circumstances would depend on the merits of each case. One thing for sure is that anything that makes the case to be ordinary like any other case would not be exceptional. The whole idea is to bring legislation to life. State versus Matshidiso 2010, Volume 1 SACR, at page 55. This case show in a better understanding of what exceptional circumstance is. Just like the applicant in this case, Matshidiso had alleged that the state case against him is weak, as the defense in his case stated that the evidence of the state witness will be weak as he is a drug addict. And the Supreme Court of Appeal held in that matter that the onus rests on the applicant in bail proceedings to prove on a balance of probabilities that he will be acquitted of the charge. And that until the applicant has set up a prima facie case of the prosecution, failing, there was no call on the state to rebut his or evidence to that effect. And the appeal in that case of refusal of bail was dismissed. The applicant before this court was expected to do the same. She did not, save to say she will plead not guilty during trial and knows nothing about murder. In the case of Pro then, 2004, Volume 2 SACR, in determining whether or not a bail applicant has established the existence of extraordinary circumstances within the meaning of Section 611A, the court has to make a decision on the facts judged with the context of the particular case. In the case of State versus Hudson, 1980, Volume 4 at SA, it was held that the expectation of a substantial sentence of imprisonment would undoubtedly provide an incentive to the applicant to abscond. And the state in the present case had submitted that the applicant, if released on bail, may evade trial. State versus Long 1, 1979, Volume 4 at SA, page 112. The court may rely on investigating officers' opinion that the accused will interfere with witnesses if released on bail. In deciding whether to grant bail or not, the court has a duty to weigh up the personal interests of the accused against interests of justice. The question that was posed to the applicant was whether any unlicensed firearm or the question that was posed by the defense to the IO was whether any unlicensed firearm was found in applicant's homestead, and the response was no, it was only the magazine which did not belong to the applicant's firearm. In bail proceedings, the question is not about the guilt of an accused, but whether the interests of justice permit the release of the accused on bail. And the determination of interest of justice is detailed as follows in section 60, subsection 4. The determination of interest of justice is detailed as follows in section 60, subsection 4. The interests of justice do not permit the release from detention of an accused when one or more of the following grounds are established. Where there is likelihood that accused, if he or she is released on bail, will attempt to evade trial. Where there is likelihood that the accused, if released on bail, will attempt to influence or intimidate witness or conceal or destroy evidence. Where in exceptional circumstances there is likelihood that the release of the accused will disturb public peace or undermine the public peace or security. In the present case, the investigating officer testified that he has fear that if applicant is released on bail, she may evade trial. As stated in the case of Hudson above, that because of the sentence that may be imposed on applicant if convicted, she may abscond or evade trial. And further, that there is a difficulty in arresting suspect number 3, who is her granddaughter. Therefore, she may also do likewise if released. And further, that the applicant is a danger to society, and that the community did report, so they still have those reports. And further, that her own life is in danger, as the community may then take the law into their own hands. And the attorney did furnish an alternative address, but the IO said still he has a problem. Even if she relocates to that alternative address, the community may still find her in that address. The court cannot turn a blind eye at the public interest in the matter, which has seen the members of the media filling the court benches each time this matter is on the roll. Also, the court cannot turn a blind eye to that some corners of society have lost confidence in the judicial system, with a number of incidents in which members of the community decide to take their law into their own hands, saying that the courts are not doing their job. And while we condemn such activities, the courts also have a duty not to appear to force members into it by attaching no weight to the justified anger of the community. In the light of all the above, the release of the accused person or applicant may disturb public peace. As there is evidence that the public by now, they are at peace, as there are no firearms being shot every night. And the court has come to the conclusion that there are no exceptional circumstances that have been accused by applicant. Therefore, court arrives at a decision that it will not be in the interest of justice that she be released on bail. As a result, her bail is therefore refused. For the to the date 21st. So number 2, you can stand up. case is postponed to 21st of June. It will be for the High Court date. Will both be remanded in custody. Mr. Chadu, don't forget to. Do we have any other? Okay, for adjourns?
Yeah.